Hi, it's Guy DiMartino, a Michigan City estate planning lawyer. I just wanted to jump on today, sorry about the dress, and share something with you about a conversation that I had with somebody recently. This was the nature of the conversation. Mom passed away. Sister is living in the area. Sister calls brother who lives in another state and says, Mom told me that she wanted me to have everything. You are not getting anything. And the question was, does she have the legal right to do that? Could my mother disinherit me? And I said, well, let's step back. We have a few things that we need to discuss and a few things that I need to understand in order to be able to even give good advice regarding the situation. And so my first question was there a will? Why did I ask that? Because if Mom executed a will, and in the will, Mom decided to leave everything to Sister, as long as the will met the proper form, as long as Mom was competent, and as long as Sister did not exercise any undue influence over her, then Mom could go ahead and do that. Mom does not have to give son any assets just because he's her son. So then he said, well, there's no will. And I said, oh, well, under the law, your sister can't go ahead and do that. And he said, well, why is that? Well, I'm glad he asked, because I'm going to tell you what I told him. If there is no will, then we have to follow Indiana state law. And we have to follow the statute, and the statute is the intestacy succession statute. Big word. What does it mean? It means Mom passed away without a will. And when Mom or Dad or somebody passes away without a will, the distribution of their probatable assets goes by a formula. And the formula is usually based on, not usually based, other states might be different, but in this state, it's based on the familial relationship. So here's how it works. If there was a surviving spouse, and the surviving spouse actually had these children, or at least one of these children, then it goes 50% to the surviving spouse, 50% to the children. We don't have that situation here because Dad predeceased Mom. And here we have two children. So they get the assets, 50% each under the statute. Now daughter or sister says to the brother, well, the reason why Mom wanted to do that is she was so appreciative how I took care of her the last 2 years. I gave up my job, I was taking care of her. And you want to know something? That may be true. And Mom might have really had the right idea in doing that. But under the law of intestacy, that ain't going to happen. Mom would have had to execute a valid will in order for that to happen. The law is not going to interpret what she told her daughter as she was passing away. That's not how property passes in the state of Indiana. So what do we have to learn from this? In order to keep families together, after you pass away, you need to have something written down. You need to have a will, or you need to have a trust that is clear so that the folks understand what your intent was. So even if Mom would have said or wrote a letter to her son saying, son, I really want your sister to have everything, under the law, that would not hold. The son might have said, okay, sister, go ahead and have everything, but he wouldn't have to under the law. So Mom would have had to execute a will or put everything into a trust, with the sister being either the trustee and definitely the beneficiary of the trust, or something along those lines. So there you have it. If you want to change the way that property will be distributed under the law, have the appropriate written documents so there's no question. If you have any questions about an Indiana estate matter, you can always give me a call. I am Guy DiMartino. Have yourself a great day.